Hello everyone, welcome to my channel. In this discussion, we are going to discuss about insolvency law or corporate insolvency law. And basically in this discussion or in this session, we are going to look at the general overview of what insolvency means, what entails in law of insolvency. Then after, the next other videos will specifically talk about various topics in law of insolvency, for example, like bankruptcy, administration, receivership, and other more. So this video will only concentrate on basically the overview, the picture of the law of insolvency. Now, before we start, you have to first understand what is insolvency. What does insolvency mean? Well, when you look at Section 1 of the Insolvency Act, Cap 108, defines insolvency to include bankruptcy. Now, let's also understand what bankruptcy means. When you look at again the same section, that is Section 1 of the Insolvency Act, Cap 108, remember, Cap 108, it's the revised edition. Now, when you see Section 1, Cap of Insolvency Act, Cap 108, again it defines bankruptcy to mean an individual in respect of whom a bankruptcy order has been granted. Are you seeing? Now, let's break it down. What is bankruptcy in just simple understanding? Bankruptcy simply means that a person is unable to pay his or her debts in common sense, in simple way. So now that's what we are going to start. Bankruptcy means a person who cannot pay his or her debt. I think so. If this person can't pay his or her debt, then this person is declared by court bankrupt. But however, let's first follow the procedures. We see how a bankruptcy order is made, what court considers to grant this order. And according to Section 2 of the Insolvency Act, Cap 108, provides for instances where a debtor or a person is presumed to be unable to pay their debts. So under Section 2, it provides for the first instance that if the debtor has failed to fulfill the statutory demand, then this person will be deemed or will be presumed to be unable to pay his or her debts. The second thing is that the execution of the court, in other words, like a judgment order declared by the court for this person to pay a certain amount. If this person fails to pay that certain amount, then it's presumed that this person is unable to pay his or her debts. And another instance is that if at all this person's property, all or substantially part of that property is in the hands of the receiver or another party who is handling that property, therefore this means that this person is unable to pay the debts. Reason being, this person does not have the property, the property is in the control of the receiver or the third party. Are you seeing? So these are some of the instances where the court can presume that this person is unable to pay the debts unless the contrary is revealed. Now, for you to understand this section very well, let me break it down. Where you see a debtor, wherever you use a debtor, it means that this is a person who took a debt. Are you seeing? In simple terms, a Muganda person says gwebabanja. That is a person called a debtor. Then a statutory demand. A statutory demand is provided for under Section 3 of the Insolvency Act. Now, according to Section 3 of the Insolvency Act, Cap 108, it provides for a statutory demand. A statutory demand simply is a demand notice. It's like a document, but for it, it's more of its contents. In that document, it shows the amount of the money the creditor is demanding the debtor. And this statutory demand, it's issued by the creditor to the debtor. And this statutory demand or the demand notice must be served to the debtor personally. I think it has to be served to the debtor personally, and failure to serve this demand notice or a statutory demand to the debtor personally, it will result to the debtor to set aside the statutory demand as null and void because he did not receive that demand notice. However, there are some circumstances under Regulation 36 of the Insolvency rules that provides that in circumstances whereby you cannot serve the demand notice to the debtor himself, you can either give it to his or her personal lawyer, take it to the address of that person where that person resides. You can also take it to the close, maybe family members or close friends. I think so. Those are some of the exceptions and circumstances whereby if at all you fail to get the debtor himself, then this demand notice must be in a prescribed form. It has to note and specify the amount, because now that's the essence of the statutory demand or the demand notice. It has to indicate the amount of money the debtor, I mean the creditor, demands from the debtor. However, just as any general rule, there are always exceptions. After the creditor has served the demand notice to the debtor himself, or maybe to the family relatives and so on, according in regards with Regulation 36, if the debtor fails to comply with the statutory demand, for example, paying the debt as indicated in the statutory demand, then the creditor can go to court and file bankruptcy proceedings. Now, when he files bankruptcy proceedings, the court calls upon the debtor to court. Now, this is something interesting about the law of insolvency. Now is that the debtor can set aside the statutory demand. He can set aside the statutory demand. According to Section 4 of the Insolvency Act, provides for the instances or circumstances whereby the court can set aside a statutory demand. For example, if at all the debtor proves to court that he has some property that can settle the bill or settle the debt, then the court can set aside the statutory demand. Secondly, if at all the debtor was not served, he can set aside the statutory demand. The court can set aside the statutory demand. Another thing, if at all the sum indicated there is due, maybe let's say that if at all the amount indicated on the statutory demand, the debtor already paid that amount, then the court can set aside that statutory demand. However, note this, that for a court to set aside a statutory demand, it must be satisfied that indeed you either paid back the debt or you have the capacity to pay that debt. The essence of this is that the bankruptcy proceedings should be the last resort. For example, why would you go for a bankruptcy proceedings and yet the debtor has property of which he can sell and settle off the debt? Are you seeing the essence of that? So if at all the court is satisfied that indeed the debtor has some property that which he can sell off and get the money and pay off the debts, then the court will set aside the statutory demand. Now, after understanding the statutory demand, now we are going to look at the creditors. We have two types of creditors. We have the secured creditor and we have the unsecured creditor. Now, let's try to understand these two types of creditors. The first one, we are going to start with unsecured creditors. The unsecured creditor is provided for under Section 9 of the Insolvency Act. So, there are some claims that can be brought by the unsecured creditors. Under Section 9 of the Insolvency Act provides that these unsecured creditors are these creditors that maybe give money or loan to the debtors, but the debtors do not give security. I think, like, he gives you, let me say, let me use an example of A and B. If A gives 5 million to B, and on an agreement that B will pay back the money in, let me say, 1 month. If B fails to pay that money, then A will claim for that money as unsecured creditor, reason being he does not hold any security against the loan. I see. So it's like he gave the money or the loan to B under an agreement. He did not get any security of any land or property whatsoever. He got nothing. That one, his claims are brought as unsecured creditor. Whereas when you look at Section 10 of the Insolvency Act, it provides for secured creditors, the claims of secured creditors. It provides that these are the creditors whereby they offer loans. I think they offer loans, but in return they get security. For example, if A offers 5M to B, are you seeing? B has to provide security over that money, either maybe a land title, another title of maybe any property. He has to give any security to A. Now, if B fails to pay, then the claims brought by A, these claims are called secured. He is known as a secured creditor. Reason being, his claims, he already has a security. Are you seeing? So these are the two types of creditors that we have: the secured and unsecured. The secured, the creditors have security, like property or land or whatsoever. Then unsecured, these creditors do not have any security over the loan. So basically, that's the introduction or the preamble or origin of the law of insolvency, what it entails, who are the people responsible, or who are the people that can be declared bankrupt, and which creditors, which claims do they have, the types of creditors. And in the next videos we are going to look at various topics. And if at all you found this video helpful, kindly please like, subscribe, share, so that other colleagues also find it helpful. Thank you very much.